every day, and they fucked it up.
Good afternoon. Today is Tuesday, April 7th, and if it feels like Groundhog Day, we are going to roll tape again. Here we go. All right, so Senate Bill 294, is there a favorable motion? Is there a second? Second. All right, so Senate Bill 294 has a favorable motion and a second. Are there any questions or any need clarification? Delegate McComas.
Just real quick, Madam Chair, if it's identifying.
Your mic.
Oh, I'm sorry. If it's identifying information, would that also include the victim's place of work? Because it would identify the victim. I know it says that their telephone number and their address, but was wondering if it would, in other words, anything that was identifying, is that kind of a broader definition?
Just one moment, please. This bill actually doesn't talk about that, but there is a section in the code that we would need to look.
My colleague says it does. 11, Section 301, Criminal Procedure provides certain protections from release of address or phone number of victim or witness in criminal proceeding. So, release of victim or witness. Well, but I don't know. Does that also include work? It still doesn't really. Okay,
just a second. We have counsel who has the answer.
All right.
Well, on page 2, identifying information is defined. It says means the name of and any other information that could reasonably be expected to identify a victim.
Okay, that's good. Covered it.
Thank you, counsel. Okay, so we're good. Are there any other questions? So let me just clarify one other thing, and that was with respect to the petition. So it seems that the entity that needed the information would petition to order the disclosure of the information. And I just wanted to make sure that that's correct. Is that correct, Claire?
Yes, the Health Occupations Board.
Yeah.
Yes.
Okay, great. Are there any questions? Okay. All right, seeing none, please call the roll.
Senate Bill 294, Senator Love, Criminal Procedure, Protection of Identity of Victim of Sexual Assault or Stalking. The Vice Chair. The Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes aye. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes aye. Delegate Phillips. Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes aye. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. Delegate Boucher is absent. Delegate McComas. Delegate McComas votes aye. Delegate Moreno. Delegate Moreno votes aye. Delegate Arcon. Delegate Arcon votes aye. Delegate Taylor. Delegate Taylor votes aye. Delegate Simpson. Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes aye. Delegate Moon. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway votes aye. Delegate Woods. Delegate Woods votes aye. Delegate Williams. Delegate Williams votes aye. The tally is 18-0001. The motion carries.
Thank you. Moving on to Senate Bill 320. Is there a favorable motion?
Second.
All righty. So this bill, Delegate Taylor, did you get a chance to move this bill? Did did they beat you to it? No. Oh, you were first. Okay. All right. Very good. Very good. Very good. Always be first on the motion for your cross-file bill. Lesson number 57.
And the cross-file is moving nicely across the street.
And the cross-file is moving nicely across the street. That's good. There is an amendment to the cross-file, but what we have before us is what the Senate did in Senate Bill 320. And okay, that's all right. We're going to move this. We're going to move this.
Oh, we're not going to be. Okay.
No, we're going to move this, and they're going to pass that. Yeah, yeah. We'll work. Yeah.
Better pass this. We need this bill, y'all. I will come and find you. That's all.
Getting you a sponge.
I second it.
Okay, so So with respect to this bill, it is not in the same posture as the House bill that we passed. However, it is my understanding that the House sponsor is fine with the amendment as the Senate has amended the bill. Correct? Okay. Are there any questions? Does anyone wish to hold the bill?
Are you playing games?
All right. All right. Seeing no questions or holds, please call the roll.
Senate Bill 320, Senator Muse, criminal procedure, expungement, no finding in case terminated without finding. The Vice Chair. The Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes aye. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes aye. Delegate Phillips. Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes aye. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. And Delegate Boucher is absent. Delegate McComas. Delegate McComas votes aye. Delegate Moreno. Delegate Moreno votes aye. Delegate Arcon. Delegate Arcon votes aye. Delegate Taylor. Delegate Taylor enthusiastically votes aye. Delegate Simpson. Delegate Simpson very enthusiastically votes aye. Delegate Mangione. Delegate Mangione votes aye. Delegate Moon. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway votes aye. Delegate Woods. Delegate Woods votes aye. Delegate Williams. Delegate Williams is excused. The tally is 17-0011. The motion carries.
Thank you. We're going to move on to Senate Bill 447. And here I would, there are amendments, so I would ask for a motion to conform the Senate bill to the House bill. Thank you. Is there, and I heard a second? Yes. Okay. So, so the change that we made in the House, or what our House bill looks like, and versus what the Senate bill looks like, I'm going to ask Lauren to just briefly explain how we're conforming the Senate bill.
The House bill specified that the purpose of the disclosure of the record must be to determine the suitability of an individual for employment or voluntary service.
Okay, so translation, we did it right, and we got to get there. We got to get the Senate bill in the same posture. So are there any other questions on the motion to conform the Senate bill to the House bill? All right, seeing none, please call the roll.
Senate Bill 447, Senator Guile, child abuse and neglect, disclosure of reports and records. The Vice Chair. The Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes aye. Delegate Embry. Delegate Embry votes aye. Delegate Cardin.
Yes, because Delegate Eric Hand voted, the only person who voted no on this is voting yes.
Thank you for calling me out. I'll be a no again.
And Delegate Cardin votes aye. Delegate Phillips. Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes aye. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. Delegate Boucher is absent. Delegate McComas. Delegate McComas votes aye. Delegate Moreno.
Voting yes because we got yes vote over there.
For the record, Delegate Moreno votes aye. Delegate Arcon.
No with the 38 other Republicans that voted no on the cross file on the floor.
Delegate Arcon votes no. Delegate Taylor. Delegate Taylor votes aye. Delegate Simpson. Delegate Simpson votes aye. Delegate Mangione. Delegate Simpson votes aye. Delegate Mangione.
Excuse me. This is the Senate version conforming to the House.
Right.
Yes.
We're not giving it to anybody.
Right.
The vote continues.
Delegate Mangione.
Hold on, we still have a voting going on. Delegate Mangione.
Are we on the automobile?
No, ma'am. We are on Senate Bill 447. Delegate Mangione votes aye. Delegate.
Oh, I was a yes on that, wasn't I?
Would you like to change your vote, Delegate Arcon?
Messed up voting.
Listen, everyone, if you need to change your vote, you'll have that opportunity, but we're in the middle of a vote session. So let's get to our next member for a vote, please.
For posterity, Delegate Arcon has changed her vote from a red to a green. We are now on Delegate Moon. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway votes aye. Delegate Woods. Delegate Woods votes aye, and Delegate Williams is excused. Is Delegate Williams? Yes. Delegate Williams votes in the affirmative. The tally is 18-0001. The motion carries.
Thank you very much. That was easy. Okay, let's move on to Senate Bill 469. And we have an amendment. Senate Bill 469. We have an amendment. The amendment merely adds Maryland automobile insurance. And so, Council, would you consider that to be a technical amendment?
Yes.
Okay, so it's merely a technical amendment. Could we move the amendment? Move the amendment. Second. Okay. All in favor of the technical amendment, please raise your hand. All opposed to the technical amendment, please raise your hand. Okay. The motion passed. Now, on the bill as amended.
Move the bill. Second.
Thank you. We have a motion and a second on favorable with amendment on the bill as amended. Are there any questions? All right. Seeing none, please call the roll.
Senate Bill 469, Senator Hayes, Maryland Automobile Insurance Fund Affordability Program and Industry Automobile Insurance Association Assessments. The Vice Chair. The Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes no. Delegate Embry. Delegate Embry votes aye. Delegate Cardin.
Yes.
Delegate Cardin votes aye. Delegate Phillips.
Yes.
Delegate Phillips votes aye. Delegate Congolo.
No.
Delegate Congolo votes no. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. Delegate Boucher is absent. Delegate McComas. Delegate McComas votes no. Delegate Moreno.
Yes.
Delegate Moreno votes aye. Delegate Archon. Delegate Archon votes no. Delegate Taylor. Delegate Taylor votes aye. Delegate Simpson. Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes no. Delegate Moon. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway votes aye. Delegate Woods. Delegate Woods votes aye. Delegate Williams. Delegate Williams votes aye and would like to explain her vote.
So this was voted out of the Senate, 10 to, well, out of JPR, 10-0, in the Senate 44-0. So I'm voting yes.
The final tally is 13-5-001. The motion carries.
Okay, next is Senate Bill 482. Is there a motion favorable?
Favorable.
Is there? Thank you. So we have a favorable motion and a second on Senate Bill 482. Is there any discussion? All right, seeing none, please call the roll.
Senate Bill 482, Senator McKay, criminal law interference with critical infrastructure or a public safety answering point. The Vice Chair. The Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes aye. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes aye. Delegate Phillips. Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes aye. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. Delegate Boucher is absent. Delegate McComas. Delegate McComas votes aye. Delegate Moreno. Delegate Moreno votes aye. Delegate Archon. Delegate Archon votes aye. Delegate Taylor. Delegate Taylor votes aye. Delegate Simpson. Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes aye. Delegate Moon. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway votes aye. Delegate Woods. Delegate Woods votes aye. Delegate Williams. Delegate Williams votes aye. The tally is 18-0001. The motion carries.
Thank you. We're going to move to Senate Bill 524. Is there a motion? Thank you. There's a favorable motion and a second on Senate Bill 524. Are there any questions? Yes, Delegate Conaway.
Thank you, Chair. Was there a letter from the Baltimore City delegation in reference to this?
There was.
Wasn't this amended? Was this amended?
Yes, it was.
And did you have a
Second letter?
second letter?
I do not have a second letter that I know of.
Okay. Well, is that a problem?
It could be a technical problem, you're right.
I think,
Let's see.
yes, it is a problem.
Let's see if I can find a letter in my inbox. I, quite frankly, overlooked that, so thank you for pointing that out, Delegate Conaway.
Madam Chair, when you're ready.
Just one moment.
Yep.
I think we have someone from the delegation here that is going to respond. Delegate Embry?
I did ask this question because I wanted to make sure we were following the rules. So we considered in the House the same amendments that the Senate did and voted in favor of those amendments.
So we voted favorable on the amendment that was in the House, on the House bill?
Correct. So the amendment, so that's I checked, and I asked the chair of the delegation to check with council, which she did.
Okay. And I have another question. The information that's going to be shared with or is proposed to be shared with the mayor's office, it's subject to be shared with other offices connected to the mayor's office. Is that correct?
Well, I'm hearing some answers. Does anyone have I'm hearing partial answers. Does anyone have an answer that they want to add to that? Or just to?
I specifically, if I may,
Yes, Vice.
I specifically asked the panel that question, and they said no.
Madam Chair.
Yes. Delegate Simmons.
Yeah, in addition, I think there was, if I can recall our last testimony of them, I think they said it was a controlled number of individuals that would have access to the information during the time. So I don't know if that was like 6 or 10 people, but it was a small number of people at this point.
It was a small number of people, but in a different agency?
Yeah, let's get to that. I'm sorry to cut you off,
yeah.
Delegate Simmons, but in fact, the agencies that would have access are the Office of Neighborhood Safety and Engagement, the Office of Children and Family Success, and the Office of African American Male Engagement, as stated in the bill. Page 5, Section 9(1).
Okay, thank you.
You're welcome. Any other questions? Thank you. Seeing none.
Madam Chair.
Yes, Delegate Carter.
Thank you. Not a question, just a comment. I just, we know that the state's attorney was clearly not in favor of this, the Baltimore City State's Attorney. And I'm going to be supporting it because I think that based on the information, whether it was genuine or not genuine, the testimony from the mayor's office that they're going to use this information properly and adequately. I just hope we don't come back next year finding out that there was misuse or that there was incompetency, and then we have to do something about it. But I just want to make sure that, you know, I'm very hopeful that what we're hearing is that this information is going to be used properly.
And also Delegate Cardin, just to let you know, there is, actually to the entire committee, there is a 5-year sunset on the bill. Also, Delegate Conaway, I wanted to add, there is a qualifier to what I just stated about those agencies that would receive the information. And the qualifier is if the office is providing programs and services in conjunction with DJS to a child who is the subject of the record, so you just don't, you know, get it just for fun, for purposes directly related to supporting the treatment, rehabilitation, reentry, planning, or continuity of care. And before they're able to access and access the confidential information, I'm on page 6 now, not only entering the MOU with DJS, but they're also having to identify the specific records to be shared, the purpose and necessity of the disclosure, and limits the use of the records to the purposes described in that section, and prohibits redisclosure of the records to any other persons, requires compliance with applicable state and federal confidentiality laws, and obtain a written consent in a single document from the parent or guardian of the child who is subject to the record. Thank you. Are there any, Delegate Phillips?
I was also going to say the city is getting this information, but they'll also be legally liable. There's a piece in here that says that if that information should be used inappropriately.
Thank you. Delegate Conaway.
Is there any estimate on a potential liability for the city?
You mean the monetary amount?
Yeah,
Oh, well, that I cannot foresee.
right, we can't foresee that.
Yeah.
All right, thank you.
Thank you. Any other questions? All right, seeing none, please call the roll.
Senate Bill 524, Senator Washington, Juvenile Records Accessed by Baltimore City Mayor's Office. The Vice Chair. The Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes no. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes aye. Delegate Phillips. Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes no. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. Delegate Boucher is absent. Delegate McComas. Delegate McComas votes no. Delegate Moreno.
Yes.
Delegate Moreno votes aye. Delegate Archon. Delegate Archon votes no. Delegate Taylor. Delegate Taylor votes aye. Delegate Simpson. Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes no. Delegate Moon. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway votes no. Delegate Woods. Delegate Woods votes aye. Delegate Williams. Delegate Williams votes aye. The tally is 12-6-001. The motion carries.
Now on to, this is Senate Bill 540. Is there a motion to conform the Senate bill to the House bill?
Move the amendment.
Or is there a motion to conform?
Move the conform.
Thank you. That's all right. Second, there's a motion to conform the Senate bill to the House bill. Are there any questions? Would you like to be reminded as to what the House bill does that we are conforming? Okay, so the House bill will be, or the amendments, please, Claire, if you would let us refresh our memory so that we will have information.
It's the same substance, it's just the House bill puts it into the criminal procedure article, whereas the Senate bill has it in the business occupations and professions article. So these amendments are just moving it and making a technical correction.
And there you go. So essentially, this bill would prohibit people from promoting or soliciting for their business in the courthouse for detention monitoring services. Remember now? Yeah. Okay. So we treated it the same way we did the bondsman bill. All right, any questions? Seeing none, please call the roll.
Senate Bill 540, Maryland Judicial Conference, Home Detention Monitoring Agencies, Promotion and Solicitation of Business, Prohibition. The Vice Chair. The Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes aye. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes aye. Delegate Phillips. Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes aye. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. And Delegate Boucher is absent. Delegate McComas. Delegate McComas votes aye. Delegate Moreno. Delegate Moreno votes aye. Delegate Archon. Delegate Archon votes aye. Delegate Taylor. Delegate Taylor votes aye. Delegate Simpson. Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes aye. Delegate Moon. Delegate Moon votes aye. Delegate Conaway is excused. Delegate Woods. Delegate Woods votes aye. Delegate Williams. Delegate Williams votes aye. The tally is 17-0-0-1-1. The motion carries.
Thank you. On to Senate Bill 810. I understand there is an amendment.
Move the amendment.
Is there a second? And Delegate Moreno? I'm sorry, Counsel?
We have one amendment from the committee, and then I think Delegate Moreno has an amendment that he's sent around to the committee as well.
Okay, so let's start with the amendment from the committee, please.
The amendment, so Senate Bill 810 came over as the House sent House Bill 1341 out, and all we're doing is they took out in the Senate requiring courthouses to implement a policy. We're saying that courthouses must implement a policy and may consider the guidance of the AG. We're cleaning that up to not have shall. And there was also a screening provision that had courthouses. We removed that provision as well per the Maryland Judiciary's request.
Okay, so we should probably do, we did move the amendment, we'll do one amendment at a time. So that is what council just described was the committee amendment. Are there any questions on the committee amendment? All right, all in favor of the committee amendment, please raise your hands. Delegate Simmons, are you voting? I'm sorry. We're on the committee amendment. Thank you. Okay, the motion passed. Oh, for you folks at home, I wish you could hear what I hear. It's rather fun. Okay, on the second amendment we have is Delegate Moreno. Delegate Moreno, would you, first let's move the amendment. Is there a motion on the amendment? And Delegate Moreno, you can move it.
So I want to move for the amendment.
Thank you, and there's a second? Thank you. Okay, Delegate Moreno, can you explain to us what the amendment does?
Yeah, so it expands the definition of schools to include childcare centers, pre-K programs, K through 12 institutions, public and state-funded non-public, and higher education institutions. It also defines school areas as including all property, bus stops, and school vehicles.
No.
Objection.
Well, wait. Okay.
Objection, hearsay.
Okay.
It's not even that.
Delegate Arakan, you have a question?
Yeah. Thank you, Madam Chair. Okay, so it's been a minute since we've done this bill. So now if the amendment includes all those places, what exactly is not permitted at those locations now?
Our floor leader who presented the House bill, I'm going to ask you to explain that question. Provide an answer.
No pressure. So the amendments actually are the same amendments that we adopted on the House bill before we moved it out of committee. So we amended the House version before we voted it out of committee with those same amendments.
Oh, so this
that
is
Delegate
conforming.
Moreno is describing.
Oh, this is conforming essentially then?
No,
or
not quite.
Not necessarily.
Not necessarily.
It's not a direct.
Go for it.
Yeah, it's not directly conforming. Holly, could you please explain?
No, it's not conforming at all. These are amendments that, that's okay. That's okay. No, you're fine. This bill went through a lot of different versions. So when the bill first came in, CASA had what is Delegate Moreno's amendment, and that's essentially expanding the definition of school. He also, the amendment also requires county superintendents of schools to verify the valid warrant. He brought that language back in. We took that out because we didn't want that on the superintendents to figure out if it was a valid warrant or not. So there's some provisions here that we spoke about at length when you moved House Bill 1341, and the provisions are now back. So that's why you're thinking, but it didn't make it out of the House bill when, yeah.
It's okay, I dream about these bills.
I do have some nightmares about them. Okay, that does help a little bit, I think. So essentially what happened was these were in some form of the bill, then they were taken out on the House side and it was moved without them, and now we're putting them back in on the Senate bill and sending it back over. Has anything happened over there with the House bill? Have they taken that bill up yet? Has it?
No.
Hasn't gotten any attention yet?
They have not.
Okay. Okay, I think that's all the questions I have. Thank you.
Delegate Simpson.
Okay, so my question is related to what I said before. Have you spoke to the senator about these, like?
Yes, I've reached out, but I'm still waiting for a response from the senator. But the senator did know initially that there were amendments being made, but we didn't get the amendments till like close to noon today. So I sent them over to her office, and I haven't heard back yet from the senator.
Well, since we had them in there before, what I'm wondering is, has this already been discussed before?
So my understanding, it has been discussed. Not by me directly, but other parties
and I'm kind of looking at past you to see if
Yeah.
there's any nodding
That's fine.
going on.
So there, it has been discussed by other
Yes,
parties.
ad nauseum, it's been discussed, it seems.
Okay, and just wanted to, given the time,
Yeah,
I know
no.
that we can go to the silver room and stuff like that and
Yeah.
all that. I just want to.
I think it's in good shape as it is with the amendments, if we were to move them forward.
Okay, I mean, I love the places.
Yeah.
So, yeah, if that's not gonna.
Let the
So
kids
in
go to
other
school.
words, what Delegate Moreno is saying, he has worked his amendment.
He's worked his bill.
All right. Any other questions?
No.
All right. I'm not seeing any other questions. Please call the roll. Oh, wait, no, I'm sorry, we're on the amendment. All those in favor of the amendment, please raise your hand. All righty. All opposed? All right, the motion passed. So we're going to now, I'm sorry. Council is looking like she has a question for me. Okay, just one moment, please.
Time out.
All right. We are, hello?
Hopefully this thing did not pick up.
Hello?
Conversation.
Hello, it's picking it up now. Everyone, since there's just a little bit of confusion on Senate Bill 810, I'm going to hold it one more day, and then we will bring it out again. No worries, you'll have an opportunity to vote tomorrow. Oh, is that, I heard that we want an 8:30 vote session in the morning?
Nope, whatever Madam Chair wishes to do.
Okay, all right, we're gonna hold the bill. We're gonna move on to Senate Bill 8, please. Senate Bill 8 is, thank you. Is there a second?
Second.
All right, Senate Bill 8. This is just a straight favorable because we did not move the House version, just merely because of time. Are there any questions about the bill? Oh, you know what? Thank goodness for that, because I didn't see you over there. Okay.
I was just keep my hands up.
Delegate Archon.
Thank you, Madam Chair. Okay. I do remember the case that this was about. I believe it was the principal of a school. They created deep fake. That was horrible. And I do think there's a way to specifically tailor the bill to address that situation. But I do not love, and I'm sure somebody on here, maybe Delegate Cardin can guess what I don't love. I do not love on page 2 of 9 of the reprint where on line 16 it says serious emotional distress. That is not, I think it's too broad. That is not good. He experienced real economic harm. I mean, he was essentially like forced out of his job because of it. So there was a real pathway for remedy because of that. Obviously, physical injury is serious, but I do not like seeing serious emotional distress in there. I think it makes the language very broad. It opens it up to essentially someone who has really hurt feelings about an AI depiction of them to have a remedy. I don't like it. I don't like it at all. Some of the funniest stuff on the internet is some AI stuff about both of our parties. I laugh equally at all the jokes made, but somebody might not think it's funny. They might feel very emotionally distressed about it. And now we've got a situation where someone is in violation, and it's serious. I mean, you know, we don't want to criminally punish or even civilly punish people, but look at this. It's like felony and on conviction, imprisonment not exceeding 5 years. That is a steep penalty for hurting somebody's feelings real bad. I don't like it. I'm not a fan. I think we have done a lot of felonies this year, which, yeah, you sure. I mean, that would be a step, I think, in the right, ironically, I think it would be a step in the right direction, potentially, but I just don't think serious emotional distress is the right wording. So I don't know if the committee, if there's enough folks here who are also like, oh, I don't love it either, I would use my hold and amend if you thought that was worthwhile, Madam Chair, but I just don't love that one piece of it. For that piece of it, I would be a yes. With that piece, I can't be a yes.
I get it. Okay, so let's just, and I know you directed to Delegate Cardin, but I'm just going to add one little thing, and that is this is language that we use in Maryland law. We also use it in the criminal law article under 3-809, where we use serious emotional distress. I was looking for a definition, and the only definition, even though it says legally defined, was through AI. And while I like having AI, I didn't want to use AI for an AI bill. Delegate Cardin.
Thank you. And intentional infliction of emotional distress, which was cause of action that I remember spending a lot of time in law school on. You have to actually, it's very, very difficult to prove. It's incredibly difficult. And for those of you who remember that from law school, I think you have to show some sort of physical manifestation that ensues. Oh, I got our law student here. You have to show some sort of physical manifestation, because I tried to prove this once in a case I had, and the judge laughed me out. Like a tic or some sort of like eating disorder or something that shows that you had emotional distress, or it's unprovable. So.
Right, but we have something to add to that, Delegate Williams.
And I was just going to add to Madam Chair on page 4, line 27, I think the reason I feel comfortable is because the person may not knowingly, willfully, or with fraudulent intent utilize the information without the consent of the individual in order to cause harm. And so I think when you couple the emotional distress with that language in the bill, I feel a little bit better about having the emotional distress in the bill, because the person who is acting in this manner is acting in a way to intentionally cause harm. You see what I'm saying?
Okay. All right, so the intent then of the bill is that the person, you would have to prove before you could charge them that they fully intended to harm the person and cause the serious emotional distress. Otherwise, it would not, you could not charge them with this, or unlikely to get a conviction. You could certainly charge them, but you wouldn't be able to get likely to get a conviction. Okay, I thank you. I actually feel slightly better having that in there, that has to be knowingly and willfully. So I think, yeah, you may have changed my mind. Congratulations, you guys, you did it. I'm gonna be yes now. Go for it. Winning.
Let's take a moment of silence all. Okay, Delegate Mangione.
Thank you, Madam Chair, and to the good delegate. Because I shared the concern, but I do support the bill. And I think a situation which you would probably agree, if somebody were to put a video on YouTube or something that was like a fake type of porn video or whatnot, there's no monetary loss likely unless you got, there's no physical harm, but your emotional distress would be through the roof if that was something fake to you. I think that's where, in this case, well, unless you made a bunch of money off of it, but, so I think that's where, because I shared your concern, but then an example like that's why I would definitely support the bill as well. Thank you.
Delegate Moon, Leader Moon.
Thank you, Madam Chair. So I'm sorry, I just have some very basic questions. This is intended to cover or not cover the pornography, the fake pornography scenarios that he was just talking about? Sorry, I don't know who I'm directing this to.
It's directed to the air. So did you finish your question?
Well, so I'm curious, did we, I can't remember if we succeeded in passing the pornography one last year.
Yes.
We did?
Yes.
So.
It's my understanding that we did.
Is this not intended to cover that?
I think this goes broader than that, but I want to make sure.
The penalties are different. That's the one thing I would just flag here.
Okay, I just want to make sure that I talk to counsel for a second, because I do remember this discussion, and unfortunately, I don't have my notes in front of me on it. But Claire, I do remember us talking about the difference between pornography and this bill.
So, and I'll just throw out my general questions anyway. So when we did what I thought we did last time around was put deep fake pornography in with revenge porn, which had a 2-year, I think that was a 2-year misdemeanor. But the language is quite similar in some respects to what's going on here. And so I guess and this is a 10-year felony. And so I guess I just want to make sure we understand for the record where the lines are, where we demarcate the line between one and the other, and when the penalties kick in.
So the deep fake pornography penalty is, like you said, it is a misdemeanor, but there is no statute of limitations. So it has it's a 2-year misdemeanor with a $5,000 fine. And it is in the revenge porn statute 3-809, if anyone wants to look that up. This bill is not about pornography. It goes broader than pornography, to the point of, as we mentioned with, as Delegate Archon mentioned, with the individual who was the athletic director and used someone else's likeness, used the principal's likeness.
This is the Pikesville case.
Yes, the Pikesville case. But I take it even a step farther, and that is the AARP testimony goes into the use of artificial intelligence and deep fake representations for the extortion of funds from individuals, where there's a new scam where they call you and they pretend like they are a loved one, or they use the loved one's voice, and the loved one is begging for help, and then they get Officer Joe on the phone, and Officer Joe says, yes, this person is in big trouble or whatever, and you need to wire money immediately to, X account. So that's part of the problem. Yeah.
So on the difference, again, between the two, there's an intent to harm on this greater penalty, the 10-year felony, to 5-year felony. On the, is there an intent requirement on what we did with deep fake porns?
I got to go look at that section that I was speaking of, 3-809, I think I said.
And it would seem to me there shouldn't be, that's a little bit more strict liability if you went and posted the, revenge porn or it seems like your intent doesn't really matter as long as you didn't have consent. Yeah, it shouldn't be, but it should be in this one, since it's carrying a much higher penalty. Just flagging these things. All right, that's all.
Okay, so I'm trying to find intent here. I pulled up the law, 3-809 in criminal law, and my computer is, okay, there we go. So this is the distribution. I do not, at this juncture, and very quickly looking, I see this. You may not knowingly distribute with the intent to harm. So there is an intent requirement. With the intent to harm, harass, intimidate, threaten, or coerce the other person. That's what I'm seeing at 3809 Criminal Law, Section C. 1. Yep. I don't know. I don't know. Do we have any?
Yeah, they are awfully similar.
So what?
Look at the code and saying, it may have been deep fake porn, but I get a bigger penalty with this section of the code. I go after this section of the code. If we do this.
Well,
you give the prosecutors, if I'm the prosecutor, I take the one that's got the greater penalty.
Well, I mean, I hate to, it's kind of interesting. Yeah, that was the merger question.
Yeah.
Why wouldn't you do both?
And if it is a merger, does it go to the lesser?
If they would have to not, they would have to, one would have to be, all the elements of one would have to be included in the other, not have any additional. And then the rule of lenity would apply if both are charged.
Both were charged.
And then the lesser sentence would be the maximum. But I have not examined to see whether the elements differ. If they differ at all, then it would not merge.
They're pretty close.
Well, then, why are we?
It seems to be, yeah. This one has nothing to do with the content of the revenge porn statute or the deep fake porn statute. Okay, so I think we still have some discussion on this one. Okay. Yep, excuse me, 1 second. Delegate Moon?
And Madam Chair, I guess it does raise the question, do we intend a higher penalty for one offense versus the other? Like, in other words, misappropriating someone's likeness for a sex offense versus a financial crime or other sort of humiliation. I don't know the answer to that.
I don't know the answer to that. I think these are all good questions. Delegate Arcon?
Yeah, I think it's a little odd, and I would definitely worry. I mean, if somebody's releasing revenge porn of you, like there was some obvious intent to harm you in that respect. I don't know. I don't know if they should have a different penalty. I would say, maybe we should have some parity. And for sure, if they're like with the financial piece of it, I mean, there's obviously, aside from the criminal, you can sue people civilly to try and get some of your money back that you've lost in those situations. But I don't know. I don't know if I like them not being lined up.
Okay. Are there any other thoughts, concerns? I am hearing some unrest. Delegate Cardin.
Yeah, and maybe this is just something to think about, is just clarifying in the definitions part, making the penalties the same, but clarifying in the definition part so that you give prosecutors the ability to charge very specifically, whether it be pornography or non-pornography. I don't know if that's possible to do, but to mend this in such a way that you're using deep fakes in either case, you can more easily prove it because of the definition. Is that, and then you don't worry about whether you're having different penalties. Is that a possibility? I'm looking at you, Delegate Moon, because I thought maybe that might clarify.
Well, I guess there's a few ways to do this. You could make it the higher penalty and just put everything in that range. But this begs the question, do we actually need a distinction as if we're criminalizing now just misappropriating someone's likeness, is there a distinction as to whether it was sexual or not if the penalties are going to be the same?
Right.
It stops to matter that it was sexual.
And I would say that knowing how much time and energy was spent on the revenge porn statute, how prevalent revenge porn is generally, the definition of revenge porn, I think, is important, whether it's being charged as something that's pornographic or something that's simply just financial. I think that there would be use in having that definition. I mean, because I think that would help with the victims.
I mean, I guess my concern would be like what you guys had said. So if they do charge both and then they end up getting the lesser penalty, we will have told somebody, oh, they have the potential to get, 10 years in prison because of what they've done. And then in the end, I don't like lying to victims. I'm worried about a victim anticipating a potential outcome and this happens a lot already, but like this just adds insult to injury, I think, if we don't have some kind of consistent parity. And honestly, it's going to be a little confusing for state's attorneys because it's almost the same crime. In fact, it's this crime, the other crime is encompassed inside this crime potentially. I don't love it. And I don't know that carving out sexual content, like then we're in court, state's attorneys are arguing why is this not sexual content? Do you know what I mean? Like, it just seems a little bit, I don't love it when I think it could be remedied if we just had both statutes have the same penalty. And I don't have a strong feeling either way, which, I mean, what was the other penalty again? 2 years. 2 years, it was a misdemeanor and what? 5 years felony plus 10 years if you do it to two more people. I do know why they put it that's definitely for those phone calls where they're robbing the elderly of them. I mean, that's a horrible crime. It's a really horrible crime. I don't know. I mean, we could sit down and really try and figure out what we think the appropriate response is to make sure that we are penalizing these kind of serial bad actors who are literally just robbing people blind versus a one-to-one problem between domestic partners, which I think is a different category of issue. I don't know. I would really want, that guy should be punished too. What he's doing is disgusting, but if a person has victimized tons of people in our communities over and over again by robbing them, manipulating them with their family members' voices, I would love to see that person get a felony and up to 10 years because enough is enough for repeat offenders and people that are robbing lots of folks. But I don't know.
Okay, I want to share a couple of things with you all. I don't know that I'm not sharing this to change anyone's mind. I'm just sharing it because you all might not have seen this yet. And that is coming from the testimony of the Office of the State Prosecutor to answer the question with respect to why the penalty is so high. I also text the bill sponsor to ask that question as well. I haven't heard back yet, but this is in the state prosecutor's testimony, and they say the crime is a felony not only due to the serious adverse ramifications using artificial technology causes, but also because of the time and resources required for law enforcement to investigate the source of the technology. Discovering who committed the act often takes more than a year by the time the data is analyzed, especially if it's not known who created the deepfake. It is also a way to manipulate public information in a way that can impact people's lives, especially the lives of young people, in a very negative way. And then they go on to the high school principal situation. So that information is there. With that, I see a distinction from the deep fake porn or revenge porn is where we put it. We put it under revenge porn. And the reason being that you do know the person who's doing it, possibly. I mean, versus what the state prosecutor is saying here is the time and cost that it takes. I think that this bill is still causing some unrest. I think we can continue this conversation. We're not having a second session, a second floor session. So there's that. Oh, one more thing I wanted to state. I did speak to the bill sponsor. So apparently the penalties, what they used was the identification fraud penalties. So that's why it's the way it is. They use identification fraud penalties already in place. So that's what's going on with that. Delegate McCombs.
This is maybe a little off topic, but I wanted to ask Delegate Cardin regarding Grace's law and Grace. Did the kid that had initiated her, depression/suicide, did he ever get prosecuted?
No. Because this wasn't in when he did it, the whole reason was to get it, so.
Right. So the question is, if that would have happened today with this law, would he be prosecuted?
Oh.
He would have been prosecuted with the porn.
Yeah, I mean, he would have already been prosecuted with the, well, no, not necessarily with the revenge porn, because it wasn't.
Well, I guess what I'm saying, where I'm going is that the little girl, she, I don't know the sequence, but when he said the horrible things to her, then she hung herself on Easter, okay, which was horribly traumatic. The question is, was what the kid said or did to trigger that suicide, was that pretty contemporaneous, or was it, she was depressed and over a period of time and then did it?
I mean,
I'm just kind of curious because where I'm going with this.
I don't think this is on topic, but I know,
yeah.
But
in a sense it is because of the damage done.
Right, but it wasn't a deep fake. This was
an election.
This was pre-deep fake technology. But that being said, he did, so it was contemporaneous and it was well before. So it was going on for months.
Okay.
So, and everybody was aware that it was going on and there was nothing they could do about it at the time. Right. Nowadays, I think that there's now, statutes that would allow them to go after him. Obviously, Grace's law, but there's others, so.
Well, I guess where I'm coming from is whatever damage is done, whether it's stealing money or it's causing physical harm for the victims, that should be what ratchets up the penalties. So that's kind of how I'm looking at it.
Thank you.
I don't know if that's reasonable.
No, I see that rationale. I think we're losing the pages who are here. Pages. Oh, they're gone. I just wanted to. Thank you for stopping by. We just wanted to say thank you. Take care. All righty. Okay, Delegate Moon.
All right. I can see a couple of other simple ways of getting out of here. Here's one. If I really look at what this bill is doing, it has clauses that where the prohibition is around misuse of personally identifying information. It has, so that's financial and identity fraud, basically. It has provisions to prohibit inducing another to provide personal identifying information, again, identity fraud. Prohibition against obtaining a benefit, credit, good, service, or other thing, right? Again, identity fraud, credit fraud. All that stuff is easy. It's the part where I think we run into the issues is it also attempts to prohibit using AI or a deep fake to impersonate and cause harm to another person. It's that general one. If we just strike that general one, the rest of the bill is just about identity theft and financial crimes. And I think it's pretty simple.
Oh, can I ask a question so I can understand? So your idea is that it doesn't matter if they're deep fakes or not, because if whatever they use to coerce somebody to give this information or to do something whether they use deep fakes or not is irrelevant. And they would be able to be charged under this statute
Well,
either
no,
way.
you could leave all that language in there. It's just, there comes points in the document, like say, if you go to page 5, the bottom of 5 and the top of 6.
In the reprint or the third reading?
I'm looking at the amendment that was sent around.
The re.
You're at the part under 2I, cause harm to another?
Yeah, if you
Okay,
just look
6,
at
yeah.
that,
Okay,
the bottom of 5 and the top of 6, there's basically 3 or 4 things it's prohibiting. And only one of them is not about financial crimes. It's just a general, don't cause harm. But if you take that out, then it's, the bill is just about financial crimes, and it doesn't overlap with the porn thing we did last time.
Okay. That makes sense.
So let's just make sure we're talking about the same part. You're talking about the part that I read, or are you talking about under 2, create or distribute false records with the intent to?
No,
cause harm?
you could leave that.
Okay.
It's the very first one.
Line 32.
Okay, so cause harm to another.
Yeah, that really general one.
Yeah, so line 33 on page 5, going into page 6 of the third reading.
Yeah, but I think the other part's fine. You're proposing to keep though lines 1 through 4 though on page 6. Is that correct?
Yeah, sorry, hold on.
I'm on the wrong one.
And can you all, when you refer, can you all actually refer to the section? Because we're all working from like different copies.
Versions.
Yeah. So what section were you speaking of, Delegate Williams?
Should we be looking
I
at
was
Senate
speaking
Bill
of
third reading?
subsection
We should,
2.
okay, look at the Senate third reading version. Don't look at the.
Yeah, that's what I'm looking at.
Okay.
I'm looking at the third reading version.
And what page are we on?
Okay, one more time. Delegate Williams, explain where you are.
Subsection 2.1. Well, 2.1, if you want to be real technical about it.
Yes, and if you're looking at the third reader Senate version, it's page 6, line
Right.
5.
Yep, I see it.
Just strike that.
Yeah, the number 1, got it.
Okay, hold on, let's make sure we're doubly clear, because there's cause harm to another person appears in 2 places.
That's true.
So what we're
You might need
speaking
to
of,
get rid of it also at page 5, line 33.
right, that's,
Yes.
okay,
Yes.
okay,
Okay.
thank you. Delegate Phillips.
So interestingly enough, I'm not sure that would address the issue that happened to the principal in Pikesville. I think that's why they have the cause harm to another person. You may be able to argue that the reason he did it, he clearly did it to cause harm to that individual, but he was hoping that by causing that harm, he might benefit from it personally. So that might get him in this. But the reason that they had a challenge with figuring out what to do with that individual was because of the cause harm to the other individual. He wanted to cause harm.
Well, I guess here's what I would suggest then. Again, to stop this confusion and possible merger and whatever, if you look at 2 and 3, induce another person to provide PII, obtain a benefit, they're very specific. So we either list the harm that we want to address, or we list a crime that was committed using the AI. But I think cause harm is very, I mean, we could leave it that way, but I think the undefined nature of cause harm, you know, what conduct is it that we're trying to prohibit? It is causing this, it could lead to a lenity issue just because it's hard for us to capture, but I get it. It's probably the Pikesville case exactly that they're trying to get here.
Well, the
but I'm just
cross-file on this
suggesting,
bill was the delegate from their district, right?
yeah.
But the other, so the principal's life was completely ruined. I mean, it was destroyed. So there's no question about causing harm. The question is, if it happens again and it's done differently where there's different type of harm, you don't want to specify that it was, you caused him to lose his job and to be ostracized by the community, because it could be a different type of harm. So
It's like criminal defamation, right? I mean, this is sort of like where we're going.
Okay, let's go to a couple of other questions and give you all time to kind of marinate on your thoughts. I saw lights, now I see no lights. What happened? Did you have a?
It's related to that, so I can marinate.
No, I wanted to continue the discussion, but I wanted to include more people. Okay, so Delegate Embry.
I was trying to obey you, Madam Chair, but I would ask Delegate Moon, what would be a definition of harm? I'm struggling to think of something that would, similar to.
Harm is defined in the bill, by the way.
Just want to confirm everybody knows that.
Economic damage, physical injury.
Oh, yeah, okay.
And serious emotional.
I mean the conduct, not the harm. What's the conduct that we're actually getting at?
Don't you have, well, anyway, I think Delegate Phillips made the point already.
Okay. Here's my question. What is wrong with the bill? I'm still not hearing what is wrong with the bill. Because I'm hearing that the bill tracks with the identity fraud case, and I'm hearing that it adds artificial intelligence and deep fake representations, which we specifically need to use that language so that charges can be brought, as well as I like the part about the civil damages. I saw that somewhere, I don't see it now, but the civil damages may be awarded, as well as injunctive relief to restrain the act, and any other appropriate relief. But personally, I don't see a problem with the bill. So I just wanted to see what is the problem, what is the real problem with the bill?
Madam Chair?
Yes, Delegate Phillips.
I think the one thing that Delegate Moon has pointed out, the majority leader has pointed out, and it does give me a little pause, is we're starting at a misdemeanor with deep fake porn, and we're almost kind of by default going directly to a felony with this one. And that seems to me to be a little odd.
It is odd, but did you hear my explanation?
No, and I've read that, and I've read it in the comparison.
Not just that, but because of the identity theft, it mirrors.
No, that's what I'm saying. I got it. No, and I went back and I read the code on identity theft. Serious. But once again, so now it's a weird scenario, right?
So my point is that we were thinking that it was parallel to deep fake pornography. It is not. It is parallel to identity theft. So that, identity fraud. So that is the reason why this bill is the way it is. And simply what it's doing is taking identity theft and modernizing that, the means in which one takes someone's identity, and now the means in which they manipulate that, and everything else is identical to what we have in identity theft. So we were thinking, because of the most recent bills we've had were on deep fake pornography and everything with respect to a sexual use of someone's identity. But that's actually not the purpose of this particular bill. It's more on identity fraud.
And I get that.
Yeah.
But now I have this one clause that talks about harm, right? And what we're trying to get at with deep fake porn is harm. So that's why I say I don't know that the two track directly, the identity piece or the revenge porn piece, because I could get a judgment on this, forget the financial benefit that one might get from doing this. I could still have someone be convicted because of the harm they inflicted, and the level of harm they inflicted, which to me is more comparison to deep fake porn, because what we're trying to stop is the harm that was inflicted, correct?
I actually don't think I agree.
Okay.
I think that the issue you have is that if somebody is intent on creating deepfake harm through pornography, you're going to go through a different statute. It's just, you are. And that's okay. And if we want to change that statute, the penalties in that statute, we can discuss that at another time, but that's not relevant to this and what we're trying to accomplish here. That would be what I would say.
One more thing I wanted to add was on the harm, we're also including physical injury. Keep in mind, the way this artificial intelligence deepfake representation could go, if we want to stretch it out to its farthest situation. We also are including video and audio recording. All right, so you all know how I feel about family, right? And so now we've got a family, I'm on the phone, I'm driving, right? And I'm listening, and it's somebody telling me, my child is telling me she's in danger or she's in harm or whatever, or something of that sort, and I get in a car accident. Well, I'm going to want to recover my physical injuries for this, and possibly, depending, if I have any serious emotional distress as a result as well. But my point is, I don't know, so we have to, my point is just simply, think it all, I urge you all to think it all the way through in the sense of the harm that could be caused and the identity theft and the way that artificial intelligence can be so manipulated to the point where you just can't tell the difference between the two, just like in identity fraud. That's all.
Sure.
Well, hold on one second. I just want to make sure that
I
finish
get
addressing.
it. And look, I get it.
Just one second.
And I like the bill. And however we come down, I think I'm going to be supportive of the bill. So that's not the issue. I am stuck now on and you're saying don't compare the two, but I'm having a hard time because I think I can compare it to the identity theft section of the code, but I do think that there are parts of it that are compared to the other section of the code with revenge porn. And so I'm just challenged with that. And only reason I'm challenged is because where we start with the criminalization, misdemeanor versus felony in one, and maybe we do need to go back and look at deepfake porn and rethink that, because the harm, I believe, is similar, if not the same. But we start one as a misdemeanor, and in this one, we're starting really with the felony. And that's my only concern. I'm having a hard time with those two. I'm just having a hard time.
I got it. Leader Moon, I'm sorry, I cut you off.
No, you're good. This was very actually helpful to listen to all this, and I had to map it out, and I think I understand. My problem is my psychic discord is similar to the subcommittee chair here, and it's this. The harms listed, there's physical harms, there's financial crimes, and then there's sort of a bad thing happens kind of a harm. And they're all lumped in together in different ways, but they're confusing to me. If you cause a suicide, if you use this technology and cause someone to commit a suicide, I would say, all right, there you are, you're in the bad territory. If you use this for financial crimes and fraud, I'd say very clearly that these are all defined things. I can write it down and know exactly what it is I'm doing. And the problem is, now we are into this realm of criminal embarrassment, as I'll call it, or criminal causing reputational damage. And here I would put two people, and they're similar to me. The Pikesville principal, maybe they were not a victim of financial crime, and maybe they did not have physical harm caused to them, but they had great reputational damage. Now you put that next to people in the revenge porn statute. You had someone with actual nude photos of them distributed by their ex, and that's a 2-year misdemeanor. Or you had the fake pornography created about them and distributed, which to me has always been less than someone actually taking my photos and putting them out there, actual photos of me. That's a 2-year misdemeanor. And the fake ones going in there are also, fake photos of me being made are also a 2-year misdemeanor. But is the Pikesville principal really a 10-year felony, you know, with the reputational harm, but someone who's had their nudes dragged onto the internet is a 2-year misdemeanor? I'm not sure I agree with that. And it's this category of the non-physical, non-financial harms that's this X category, this vague category, and it's in both of them. It's this harm that we've caused through the technology. And I don't want to hold the bill up because I don't know that we're going to solve this philosophical question. But I think that's at the heart of this. If we're talking about the physical harms and the financial crimes, it's pretty easy for me. If you want to move that into a felony, it's easy to define and we know what happened. Now the problem is the Pikesville principle and the, you know, this like reputational harm part. I just think it's hard to do. But I get where everybody's trying to go with it.
And just let's make sure that we also are clear that this bill does have tiers. It does start a section with misdemeanors, okay? So if you are guilty of B1 and B2 misdemeanor, B1, B2, C1, C2, et cetera, guilty of a misdemeanor, and a 1-year fine. F2 is where we get into felony, and that's involving one victim, 5 years, and then section 5-2, if you have 2 or more victims, that's where we get to the 10-year. So you don't get to 10-year unless you have 2 or more victims. Okay, just to make sure that part is clear where we are. Delegate Woods, did you have something?
I wasn't clear. I thought I heard him saying that the financial was not a part of the Pikesville, but that's not what you were saying. Is that correct? So, okay, so you acknowledge financial was a part of it?
It could have been, yeah.
It was not. It was not a direct financial crime. He wasn't trying to extract dollars from the principal.
So it's not a financial crime even though the principal lost his sense of income?
So it was a financial crime to the principal lost, but it wasn't as if the coach, right, had a civil thing. Now, you could go way down the line and say the whole reason he did it was not to extract money from the principal, but to keep his job as a coach. And so you could potentially argue that he had a financial interest in the reason why he did it.
Mm-hmm.
I mean, that's case specific. So the prosecutors would have to figure that out.
Okay. All right. Thank you. Thank you, Madam Chair.
And thank you for articulating my, Mr. Majority Leader. Yeah, no, but Majority Leader, thank you. You articulated my concerns better than I did. Thank you.
He has a way of doing that.
He does. He does.
Delegate Card and then
Thank you.
Delegate.
I just wanted to respond to your cognitive dissonance there on the 2 different crimes. And so I was the sponsor of the initial revenge porn way back 15 years ago. And I had a number of women who came forward and testified. And many of them, their reputations were destroyed. It was horrible. It was something that they could never take back after it was put out there. Some of them were devastated. Other ones picked up by their bootstraps and managed to go and have a very successful career and managed to deal with their family issues. In this case, with this principal, when I say he's unable to get a job, unable to make money, unable to have any credibility in the area that he spent decades trying to become an expert and being an expert because somebody else made up something about him and did it. So granted, it's different. Yes, it's not a sexual crime. I understand that. And I would like to make sure that people who are impacted by deep fakes in the sexual realm are made right as well. But in this case, should the culprit face a felony because he has literally destroyed somebody's, not just, he just can't, he can go and become a plumber, but he cannot work in education. right? I mean, he's just done. So nobody wants to take that risk. So I'm just putting that out there. So you have to look at it. It's kind of apples and oranges.
Madam Chair. Delegate Arakan, she's just been waiting. Okay, and then we'll circle back to you.
I was just going to put a bow on it. I now see on page 7 where it outlines that for B1, B2, C1, C24, E, or F1, that you would first be guilty of a misdemeanor, 1 year, fine not exceeding $500 or both. And then if we go up, F2 is where it starts with the felony under F2. So I guess you're right, there is a tiered system that, because it was existing language, was easy to skip over and not see it. But, so I don't know if that makes anybody feel better. There is some kind of tiering going on, and it does start with actually what looks to be a lower penalty even than the revenge porn statute. So I don't know. I think I feel a little more comfortable with it, and knowing we can pass this and still, I don't think passing it would cause a catastrophic outcome that negatively that we can't address next year if we come back and see that there's tweaks that need to be made. Because it does look like it's stepping up and not just jumping right up to a felony right away.
Yes.
Thank you, Delegate Arakan, because I'm looking at the same page. That gives me less concern. Also, lines 12 through 16 on the same page gives a little more discretion for the judge or the determiner of the sentence. When the violation of this section is pursuant to one scheme or continuing course of conduct, whether from the same or several sources, the conduct may be considered as one violation, and the value of the benefit, credit, good, service, or other thing of value may be aggregated in determining whether the violation is a, bingo, felony or misdemeanor. That actually makes me feel better. I would move the vote.
Yay. We haven't heard that all session.
Move the previous question.
All right, so since we haven't heard that all session, I will, for the benefit of anyone who may have forgotten or may be new, that means now we call the motion and we call the vote. Okay, and it is non-debatable. All righty. Please call the roll.
Senate Bill 8, Senator Hester, Criminal Law, Identity Fraud, Artificial Intelligence, and Deepfake Representations. The Vice Chair. The Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes aye. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes aye. Delegate Phillips. Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes aye. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. Delegate Boucher votes absent. Delegate McComas. Delegate McComas votes aye. Delegate Moreno.
Enthusiastic, yeah.
Delegate Moreno votes aye. Delegate Arakan. Delegate Arakan votes aye. Delegate Taylor. Delegate Taylor votes aye. Delegate Simpson. Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes aye. Delegate Moon. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway votes aye. Delegate Woods. Delegate Woods votes aye. Delegate Williams. Delegate Williams votes aye. The tally is 18-0-0-0-1. The motion carries.
Thank you, members. Hold on 1 second before you get up, please. Delegate Williams.
Madam Chair, unfortunately, I had to step out of the room for the vote on SB 320. I wanted to ask my colleagues if it's okay.
Favorable.
All in favor of allowing Delegate Williams to vote, even though she was inevitably sent away? Raise your hands. Okay, everybody's raising their hands. Looks like a favorable. Hold on 1 second. We have a question on the motion. Delegate Connell.
And on to her question. On House Bill 540. Consent. Thank you.
Okay, so Delegate, on Senate Bill 540, would you please, Delegate Conaway, give your vote? Yes. All right, and Delegate Williams, I'm not sure which ones you missed.
It was SB 320.
For the record, Delegate Williams votes in the affirmative on SB 320, and on Senate Bill 540, Delegate Conaway votes in the affirmative.
All righty. Thank you. All right, you all, thank you very much. That was a great, excellent discussion. We are adjourned.